Absent.
Yes.
Yes. Yes. Yes, appearances. We don't have any representation. Can you call the second case, please, so that we will be sure we have representation? Do we have representation for the second?
Oh my Lord.
Yes.
Call the
Yes. Case number 2, NICH/KD/11/2022 between Honorable Magaji Musa Buba and 1, the local government area Kaduna State, 2, the Ministry of Local Government Affairs Kaduna State, and 3, Attorney General and Commissioner for Justice Kaduna State. My Lord, parties absent.
appearance, please.
May you please, my lord?
Yes.
After my lord, for the claimant, sorry.
For the claimant?
Yes, my lord.
No legal representation for the defendants? Ruling. Hence the present action by complaint and statement of facts filed on the 22nd of March 2022 against the defendant from payment of a severance allowance, damages, and other reliefs. However, the originating processes in the suit, the defendant and a conditional appearance filed a notice of preliminary objection on the 27th of April 2022 to challenge the competence of the suit and the jurisdiction of the court predicated on the grounds. 1, the suit defendant's applicant constituted is incompetent as no valid pre-action notice was set defendant's applicant. 2, there is no and or irregular service of court processes on the first defendant's applicant, robs this honorable court with the jurisdiction to entertain this case. Learned Counsel's written address was filed along the originating processes, wherein 2 issues were formulated for determination, namely 1, whether the suit is as presently constituted is incompetent in view of the claimant's respondent's failure to serve competent applicant. 114 Kaduna Local Government Law number 3 of 2018, 2, where the claimant's respondent's failure to effect proper service on the first defendant's applicant robs this honorable court the jurisdiction to entertain this case. In reaction to the objection, Learned Claimant's Counsel filed a written address deemed filed on the 20th of October 2022. The reply on points of law of Learned Defendant's Counsel was filed on the 27th of October 2022. I had carefully considered the totality of the processes filed on both sides to support and oppose the instant objection, which was argued on the 15th of February 2022. I had also taken cognizance of the totality of the written arguments of Learned Counsel on both sides. Make reference as I of this ruling. In this submission, Learned Defendant's Counsel, I, Shuaibu Esquire, argued that this suit is incompetent, having been filed without sending the first defendant with a competent valid reaction notice required by Section 114 of Kaduna State Local Government Law 2018. Learned Counsel further argued that by the said law, 1 month's notice in writing served on the local government indicating the intention of a plaintiff or its agents to commence an action against it, that the intending plaintiff must provide sufficient particulars of himself, the course of action and his residence, and the word shall in the said provision makes the pre-action mandatory. Like Defendants Counsel contends that the defendants have not waived his statutory rights by the present objection, and further submitted that one of the factors for determining the jurisdiction of a court is that the action must have commenced by due process of law, and that a suit commenced in default of service of valid pre-action notice robs the provisions of Section 114, sub 1 and 2 of Kaduna State Local Government Law, Supra, and Judicial Authorities of Ministry of Education. Anambra State versus Asifo, the case of CAC and Government Council were cited to buttress this submission. On the issue of irregularity of service of originating Learned Counsel hinged its arguments principally on the provision of Section 1 of the Kaduna State Local Government Law 2018, and submitted that a valid service of originating processes and other court processes is a precondition and fundamental to the exercise of the jurisdiction of a court. Learned Counsel submitted further that where a statute makes a clear provision on the procedure of doing an action, such statutory procedure must be complied with. Learned Counsel argued that the service of the originating processes on the personal assistant, that is the PA, of the chairman of the first defendant is irregular service and ought to be set aside for non-compliance with the provision of the law. He finally urged the court to hold that the suit is incompetent and that it lacked jurisdiction to entertain same. Adopting the issues as formulated by Learned Defendants Counsel for determination, B.A. Damshakal Esquires argument in turn, essentially to the effect that the claimant's respondent had served the first defendant a valid pre-action notice as required by law. Learned Claimants Counsel argued that a pre-action notice is usually in a form of letter written by the plaintiff or a solicitor to the defendant, and submitted that the essence of the pre-action notice is to give adequate time to prepare for defense. Learned Counsel further argued that the course of action was categorically stated on the title or heading of the pre-action notice served on the first defendant on the 1st of February 2022, and that the main claim and other reliefs were reflected in the content of the said pre-action notice. The cases of Abuja Municipal Council versus CN Okoli Transport Company Limited, the case of Public and Private Development Center Limited / GTEPPDC versus NNPC and another, the case of Mekea Wolu versus Uka West Local Government Council were cited by the Learned Counsel apposite. On the issue of irregular service of the originating processes, Learned Claimants Counsel argued that the purpose of service of originating processes is to bring to the notice of the defendant the pendency of an action and to give adequate opportunity for the defendants to take appropriate action. Learned Counsel further contends that lack of proper service of court processes is an irregularity that does not abrogate the right of the claimants to approach this honorable court or defeat his course of action for dismissal of his case. He finally urged the court to dismiss the objection as same is an attempt by the defendants to further frustrate the claimant's claims. It is now settled and as correctly submitted by respective Learned Counsel of both sides that the issue of a court's jurisdiction is the bedrock of a case and fundamental to the question of the competence of the court adjudicating. Therefore, it is an exhibition of wisdom to have the issue of jurisdiction or competence determined before embarking on hearing and determination of substantive matter. See the cases of Masakoni Limited versus Aspinal, the case of B.A. Shitabe versus A.G. of Federation and other, the case of Salisu and another versus Mobology and other. Citation also applied. The position of the law on the issue of pre-action notice is clear and has been adequately captured by respective learned counsel. In the instant case, the contention of the learned defendants counsel is that the claimant failed to comply with the statutory requirements of issuance of pre-action notice of the first defendants as provided in section 114 sub 1 and 2 of Kaduna State Local Government Law 2018. The said law provides that, I quote, no suit shall be commenced against the local government until 1 month at least after a written notice of intention to commence the suit shall have been served upon the local government by the intending plaintiff or his agent. Sub 2, such notice shall state the course of action, the name, the place of abode of intending plaintiff, and the relief which it claims, end of quote. Essentially, the rationale behind the jurisprudence of pre-action notice is to enable the defendant know in advance the anticipated action and to decide what to do in the matter, whether to negotiate or reach a compromise or have another look at the matter in relation to the issues and decide whether it is more expedient to submit to jurisdiction and have a pronouncement on the point in controversy. See the case of Amadi versus NNPC, 2010 Nigeria Weekly Law Report, part 674, page 76. It is equally settled and as correctly submitted by learned defendants counsel that where it is shown that there has been non-service of pre-action notice, the court is bound to hold that the claimant has not fulfilled a precondition for instituting his action. In other words, where there is non-compliance with the stipulated pre-action condition for setting a legal process in motion, any suit instituted in contravention of the relevant law is incompetent, and the court of law, for that reason, lacks jurisdictional power to entertain it. See the case of Noye versus Ayichi and the case of Ugurude versus EcoBank Limited and others, citation supplied. In this case, the learned defendants counsel conversed in his written address that the claimant did serve the first defendant with a notice of intention to commence suit. The grounds of the applicant is, however, that the notice served by the claimant did not clearly and explicitly state all the reliefs claimed and the place of abode of the claimant as specifically required by the law. In essence, the complaint that the pre-action notice served by the claimant is defective is for non-compliance as to the contents of the notice, as prescribed by section 114 of the law, and not that the pre-action notice was not served. I have carefully examined all the authorities cited by learned defendants counsel. The cases were not decided on the basis that the action is nullified by failure of an intending plaintiff to state the particulars of his claim and place of abode as stipulated by the prescribed statutes or laws. In other words, if it is proved that pre-action notice was issued and served on an intending party, then substantial compliance with statutory provision has been satisfied. The Apex Court made this point clear in Amadi versus NNPC Supra, where Uwe's CJN as it then was at page 99 to 100 held as follows, I quote, I do not consider the place of abode of the plaintiff as material to expressing his intention to sue the defendant. After all, should the plaintiff issue a writ of summons, which he later did, his address of service will be contained in the writ. At any rate, the plaintiff was no stranger to the defendant, having been its employee and having been shown to have exchanged correspondence with the defendant after a suspension from duty and dismissal. Perhaps the situation will have been different had the defendant been dealing with a complete stranger and not its employee, end of quote. As I stated earlier, it is not in dispute that a pre-action notice was served on the first defendant by the claimant. I had carefully reviewed the content of the pre-action notice, front-loaded with the processes, dated the 2nd of February 2022. From the content, the fourth defendant was notified of the intention of the claimant to institute an action against the first defendant for alleged claim of his severance package and several allowances. I cannot agree more with the Learned Claimants Council that it would be inequitable to regard such a situation as in the instance case as equivalent to absence of notice merely because the claimant did not state his place of abode. If it is otherwise, the situation will have been erected of an unnecessary and improper legal impediment to access to courts, inconsistent with the constitutional rights of the courts under Section 6 of 6B and of the citizen under Section 36, sub 1 of the Constitution of the Federal Republic of Nigeria as amended. Based on the foregoing, therefore, the pre-action notice dated the 2nd of February 2022 and served on the Secretary of the served on the PA of the Secretary of the first defendant chairman is not defective service, and I so hold. On the second leg of the attack, Learned Defendant Counsel contains that by the provision of Section 115 of the Kaduna State Local Government Law, the originating processes ought to have been served on the Secretary to the local government On the second leg of the attack, Learned Defendants Council contends that the provision of Section 115 of Kaduna State Local Government Law, the originating processes, ought to have been served on the Secretary to the local government of the first defendant, and that the originating process is purportedly served on the PA to the chairman of the first defendant is irregular and same should be set aside for non-compliance with the said law. It is elementary to state that service of originating processes is an essential aspect of Nigerian procedural law and a condition precedent to the exercise of court's jurisdiction to adjudicate on a matter. Where the originating process is not served on the defendant, the court's proceeding, including any judgment or decision resulting from the proceeding, is rendered a nullity. See the case of Idigbe versus Ekrodil, Nigeria Limited versus others, to the case of Idigbe versus Oshi and others, the case of Ihedioha and another versus Okorocha and others, citation supplied. Now, the salient question is whether failure to comply with the provision of Section 115 of Kaduna State Local Government Law 2018 is a mere irregularity that can be cured as posited by Learned Claimants Council in his written address. In the determination of this issue, it is appropriate to consider the said provision of Section 115 supra. It provides as follows. I quote, the notice referred to in Section 114 and any summons, notice, or other documents required authorized to be served on the local government in connection with any suit by or against such local government in connection with any suit shall be served by delivering same to or by sending it by registered post addressed to the secretary to the local government at the principal office of the local government, end of quote. As correctly submitted by learned defendants counsel, the endorsement on the proof of service stated that same was served on the PA to the chairman of the first defendant. Learned defendants counsel had submitted that the use of the word shall makes service on the secretary of the local government mandatory. Therefore, any originating process without being served by delivering same or sending it by registered post addressed to the secretary to the local government at the principal office of the local government becomes invalid. In reaction, the submission of learned claimants counsel on this issue is that improper service is considered as irregularity that does not abrogate the right of the claimants to approach the courts. As correctly submitted by learned claimants counsel, it has been held in a plethora of cases that ipso facto, defective service of an originating process does not render the process incompetent as to affect the jurisdiction of the court to adjudicate over the process. In such a situation, the court is seized of the requisite jurisdiction to set aside the defective service and order for proper service of a process validly and properly issued in accordance with the rules of court. See the case of Benin Pharmaceutical and Chemical Company Limited versus Italy and other. 2017 Law Pavilion Electronic Law Report 42695. The Apex Court, Roads Vivo JFC in Idigbe versus INEC, 2018 Law Pavilion Report at 44284 held the same position where it stated as follows, I quote, if an originating process is valid, any defect in service is a mere irregularity which may make such an originating process voidable, but certainly not void. At this juncture, it is imperative to state that Order 7 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 provides for modes of effecting service of processes. By Order 7 of processes, including originating processes. By Order 7, Rule 1, Rule 1, Section H, Paragraph 4 of the rules, service of processes of a local government authority can be effected on the chairman, the secretary or supervising councillor or director of personnel of the local government council or the treasurer or any other responsible person, officer, or employee of the local government acting on behalf of that person. Now it is right, the rules of court govern the initiating of court processes and its procedures. The essence of service is to put the defendants on notice of the action. It is apparent that the objection of learned defendants counsel is not against the validity of the originating processes that was served on the first defendant, but the mode of service in the instant case is the originating processes served on the first defendant as prescribed by the rules and by the court's belief, who are guided by the rules of the court's invalid or defective. My answer to the poser is an emphatic no. In my view, the objection taken as to the competence or otherwise of the irregularity of service of originating process on the first defendant, simply because the court's belief complied with the rules of this court is an unnecessary way of promoting technicality at the expense of substantial justice. The attitude of this court is based primarily on doing substantive justice without much adherence to any form of technicality. The decision of courts are replete with admonitions directing that on no account should technicality be allowed to stand on the way of substantial justice. See the case of Bello versus Attorney General of Oyo State, 1986, 5 Nigeria Weekly Law Report, part 45, 828 at 831 to 837, where it was held as follows, I quote, "It is not necessary that the provisions of a statute be met strictly to the letter. What matters is a substantial compliance. The court is more interested in substance than in mere form, as justice can only be done if the substance of a matter is examined, rather than relying on mere technicalities," end of quote. Having carefully considered the circumstances of the present case, and therefore unable to disagree with the learned claimant's counsel, that the objection raised does not amount to a nervous adherence to form. The fact that the defendants were not in any way misled is clearly obvious. I do not also think that the fourth defendant has suffered any prejudice by serving the process on the PA of a chairman, which by the rules of this court is proper service. In the circumstances and in the interest of justice, the originating process is served on the PA of the chairman of the first defendant, and in accordance to the rules of this honorable court, is valid and proper service. And I so hold. On the basis of the following. Therefore, my decision is that this court is competent in law to exercise jurisdiction to entertain the suit. I therefore hold the defendant's objection is clearly unmeritorious and is hereby accordingly overruled and dismissed. Parties shall bear the courts.
Okay. As a court pleases, we are grateful, my Lord, for the well-considered decision. May we humbly apply for a date for hearing of our claim.
Does the 6th of June be convenient, please?
Sorry, my Lord, I didn't get that.
6th of June. 06/06/2023.
I don't know if we can have the 7th of June.
7th is not convenient. Can you check your 14th?
Fourteenth is convenient.
Court case is adjourned to the 14th of June 2023 for hearing. Hearing notices shall be issued and served on the defendant.
May it please, my Lord.
Yeah.
Sorry, my Lord, I had network issues joining late.
Yes.
My name is Aishu Aibu.
Yes.
Yeah, I represent State Council. I represent the defendants.
So you.
Yes, my Lord, we appreciate this ruling and we are going to put our house in order before the set adjourned date.
And when you are putting your in order, remember.
My Lord is breaking. I can't get the message. I can't hear.
Putting your house in order, remember that you will put costs in order too, because you are already in default of your statement.
As the court pleases.
Thank you.
Thank you very much.
Yes, please.
Case number 1, NICS/KD/07M/2022 between Albert and Mustafa and 69 others, and 1, Governor of Kaduna State, 2, Attorney General of Kaduna State. By no same appearances.
No, what's happened? Did you record that it is same? Appearance of this matter, what we said is that the judgment creditors are present. Yeah, appearances, please.
May my lord be pleased?
Yes.
I'm MP Danjuma.
Yes.
State Council.
Yes.
For the applicants, my lord.
Judgment letter.
Yes, my lord.
Yes. Any representation?
May my lord be pleased?
Yes.
FJ Imaku
Yes.
for the judgment creditors respondents. My lord.
Yes, thank you. Ruling.
As purposes.
I had carefully considered the totality of the arguments canvassed by learned counsel for both sides with respect to their present application, by which the defendants, judgment debtors, applicants herein have praised this court for the following orders. 1, an order staying execution, enforcement, and or further execution, enforcement of the judgment delivered by the court in favor of the claimants, judgment creditors, respondents on the 7th day of July 2021 in suit number NICN/KD/22/2020, pending hearing and determination of the appeal lodged by the judgment debtors applicants against the judgment at the Court of Appeal. 2, an order of injunction restraining the judgment's creditors, respondents themselves, or through their agents, and such other persons howsoever described, or any of the judgment creditors, respondents from giving effect whatsoever to or enforcing the judgment, and or from implementing or further implementing the declaratory order delivered on the 7th July 2021 and 11th day of January 2022, and suit number NICN/KD/2022/2020, pending hearing and determination of the appeal lodged against the judgment at the Court of Appeal, as correctly submitted by learned counsel for the judgment debtor applicants, Sanusi Usman Esquire. It is not in doubt that this honorable court is empowered by its rules to, upon application, exercise its discretion either to grant or refuse an application for stay of execution of its judgment, pending determination of an appeal lodged against the same, and for an application for injunction. The simple task the court is to undertake now is to examine the facts as set out in the totality of affidavit evidence filed to support and oppose the application in order to determine whether or not the present application can succeed in the present circumstances of this case. As a starting point, I find it crucial to place on record the antecedents of this case. It is not disputable that judgment was entered in favor of the respondents on the 7th of July 2021 in the sum of 984,405,659 naira 68 kobo. Having failed to pay the judgment sum, leave of court was granted to the judgment creditors on the 16th of May 2022 to serve Forms 48 and 49 and other subsequent processes of this court on the judgment debtors through substituted service, and a Ganishi ordinance was subsequently granted by the court on the 17th of October 2022. Thereafter, the judgment debtors filed an application on the 2nd of November 2022 to set aside the Ganishi ordinance. In a considered ruling delivered on the 7th of February 2023, the application to set aside the garnishee ordinancy was dismissed, and the ordinancy was pronounced absolute on the same day. The present application for stay of execution and injunction was filed on the 16th of March 2023, that is, when the garnishee order had been made absolute. I'm quick to remark that no judgment was delivered by this court on the 11th of January 2022 as stated in Relief 2 and Ground 3 of the instant application. On the basis of the foregoing facts, it seems to me that the pertinent question ought therefore to be this: does the garnishee order absolute as made finally dispose of the rights of the parties? This area of law in the Nigerian context need not raise any confusion, ingenuity of counsel notwithstanding. If the garnishee order absolute has determined the rights of the parties, then it is unquestionably a final order. There are case galore decided by the courts on this point to the effect that a decision of a court is final when it determines the rights of the parties. By virtue of the 1999 Constitution of the Federal Republic of Nigeria as amended, the word decision means, I quote, any determination of the court, and it includes judgment, decree, order, conviction, sentence, or recommendation, end of quote. Indeed, the character that identified a decision as being final is the lack of power of the court which gave that decision to reopen, reconsider, or redecide the matter that was decided and settled by its earlier decisions. In Fadiora and another versus Badebo and another 1978 Law Pavilion Election Declare Report 1224, the Apex Court emphatically held that, I quote, a judicial decision is deemed to be final when it leaves nothing to be judicially determined or ascertained thereafter in order to render it effective or capable of execution and is absolute, complete, and certain, and when it is not lawfully subject to subsequent decision, review, or modification by the tribunal which pronounced it, end of quote. Kutugi JSC in Ojutola versus Oderide, 2004, 12 Nigeria Weekly Law Report, Part 8, 888 at 574 restated the position of the law as follows: an order of decision is final when it finally disposes of the rights of the parties, that is to say, the decision or order given by the court is such that the matter will not be further brought back to the court itself, as in this case, end of quote. See also the cases of Western Steelworks Limited versus Iron and Steel Workers Union, and another, the case of MSC versus Oswagu, the case of Union Bank of Nigeria PLC versus Boni Marcos Limited, and others. Citation also applied. As correctly submitted by Learning Counsel for the judgment creditors, Mercy Umar Esquire, that the garnishee order, absolute order made on 2nd of February 2023 is a final decision, and that the present application is brought mala fide. It is not incontestable, but it is not only incontestable, but indisputable that the said order refusing to discharge its garnishee ordinancy and at the same time making an absolute order as totally disposed of the garnishee proceedings. There's nothing left to be ascertained or determined again between the parties who were involved in the matter. The only thing left to be done thereafter is no more than execution of the order so made by the court. It is settled that once an execution is completed, the court cannot order a stay of execution already on an act already concluded, on a judgment already executed. For a party to ask for stay of execution of an executed judgment is like offering a dead man medicine intended to cure his ailments, or closing the stable after the horse had bolted. Such a request is not grantable by a court of law, which does nothing in vain. See the cases of Zenith Bank versus John, the cases of Attorney General Anambra State versus Okafor, the case of Badejo versus Federal Ministry of Education, citation supplied. It is to state that it is to re-emphasize again that the judgment had been executed by the garnishee order absolute made by the court on the 7th of February 2023. It is no longer subject to another decision, review, or consideration by the courts in respective of how it was subsequently and differently constituted as in the instance matter, and I so hold. It is imperative to state that the appeal lodged by the judgment debtors, as evidenced by Exhibits H and H2, attach the affidavit in support to the present application, that is the notice of appeal filed on the 13th of March 2023, and the leave to appeal granted on the 8th of March 2023 are in respect of the judgment delivered by this honorable court on the 7th of July 2021, and that the leave to appeal was obtained after the garnishee order absolute was made on the 7th of February 2023. In other words, there is no pending appeal against the decision of the court in respect of the garnishee order absolutes. In my respective view, the judgment creditors, respondents, have so far been deprived of the fruits of the judgments awarded in their favor. Since 7th of July 2021, almost 2 years ago, this application by the judgment debtors is another classical case of abuse of judicial process. It is an improper use of judicial process and lawful procedure of the court aimed or targeting or interference with due administration of justice. It is a deliberate attempt by the judgment debtor applicants to further deprive the judgment creditors of the fruits of judgment. It must not be allowed to stand. This court has a duty to protect itself from abuse, will not allow a party litigant to abuse its process. In the final analysis, therefore, my firm decision is that the present action here constitutes a flagrant abuse of judicial process of the court. The application is refused and is hereby accordingly dismissed. A cost of 500,000 naira is awarded in favor of the respondents.
As a court, please.
As a court, please. My Lord, we are very grateful for that ruling.
Thank you.
Thank you, my lord.
Thank you. So the ruling will be ready before the end of the week, so you can apply for it. It will be sent immediately, and you can apply by tomorrow for the same.
As a court, please. I'm most grateful, my lord.
And those judgments. Thank you. The court's your right.